Thank you for joining us for this episode of Season 3 of Comply on the Fly with M3 and Karen B. Comply on the Fly is your trusted weekly resource for reliable insight and quick answers to common employee benefits compliance questions. Please note this podcast and the contents herein do not constitute legal advice. Seek the advice of counsel for any employee benefits compliance related guidance or strategy.
Hello, everyone. I'm Karen B. And the Comply on the Fly question for today is regarding another special enrollment question. An employer has several employees that are enrolled in their spouse's plan for another local employer. So, enrolled in another employer plan, not our client's plan. This local employer has decided to implement a spousal surcharge during their open enrollment, which does not coincide with our employer's plan open enrollment. Can the employees who are now going to be charged a spousal surcharge on the other employer's plan enroll in our client's plan? Many of you are probably thinking yes, because your mind goes to a Section 125 qualifying event, which addresses changes under another employer's plan. This seems logical, but it is incorrect. Section 125 qualifying event address changes needed in pre-tax premium election amounts. The change in another employer's plan event is typically used when your employee would like to join their spouse's plan because the spouse's plan has an open enrollment period that is different from yours. They need the Section 125 qualifying event to revoke their pre-tax premium election when they drop your coverage. In this situation, employees are asking to enroll in your health plan outside of open enrollment. This would be a situation in which we would refer to the special enrollment provisions of the plan. How can someone join your plan mid-year? Not through Section 125 qualifying events, because we're not talking about changing the pre-tax premium. Rather, we are talking about how they can enroll in a particular plan. And so we always answer by stating that you have to check the special enrollment section of your plan document. Typically, enrollment mid-year is allowed for birth, adoption, marriage, or loss of other coverage. In this situation, there is an imposition of a surcharge, but there is no loss of coverage or loss of eligibility for the other coverage. And therefore, in most circumstances, employees would not be able to join your plan mid-year and would need to wait for open enrollment. However, I always suggest you check that plan document and see what situations will allow for enrollment. Some plans are more generous and may simply require only a termination of the other coverage and not a loss of eligibility. In fact, if you have a fully insured plan in the state of Wisconsin, the state special enrollment requirements are less stringent and may allow for mid-year enrollment in this situation merely because the employee chose to terminate the coverage under the other employer plan. Of course, self-funded plans do not need to follow state law. So again, very important that you check the plan document. And if enrollment is allowed, special enrollment events are always Section 125 qualifying events. So you would allow a change in the pre-tax premium amount, presuming it changes or needs to be initiated when someone enrolls in your plan mid-year. And that is your Comply on the Fly question for today. Thanks for tuning in.
For more compliance insights from Karen B., please visit m3ins.com. You can also follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts.